The court meets this morning to hear South Africa, Algeria, Saudi Arabia, the Kingdom of the Netherlands, Bangladesh and Belgium on the questions submitted to it by the United Nations General Assembly regarding the legal consequences following on from the policies and practices of Israel in the occupied Palestinian Territory and in East Jerusalem. Now, as I noted yesterday, each delegation will have 30 minutes to make its oral statement and should not exceed that time.
10 minutes after the first three participating delegations have spoken, and then we'll proceed to the next three delegations. With that, I shall now give the floor to the delegation of South Africa and invite His Excellency Mr. Vusimuzi Mandozela to the podium.
Mr. President, distinguished members of the Court, this is both an honor and a responsibility of monumental proportions to appear before you today on behalf of the Republic of South Africa for the second time within 41 days. Mr. President, while South Africa's foreign policy has always favored a two-state solution, the prevailing conditions suggest that unless such an approach deals with the inequitable offering of land to Palestinians, the dismantling of all the illegal settlements, the right of return to all Palestinian refugees, such a solution may solidly lead to the disenfranchisement of the indigenous people of Palestine and concretize the prevailing injustices brought about by decades of apartheid settler colonialism. A just solution for all who legally qualify to live in historical Palestine would need to be negotiated with the assistance of the international community. The inordinate delay in achieving a fair and just settlement has resulted in an unending cycle of violence. A clear legal characterization of the nature of Israel's regime over the Palestinian people can only assist in remedying the ongoing delay in achieving a just settlement. In this regard, on the legal questions placed before the courts by the United Nations General Assembly in Resolution 77/247 of 30 December 2022, we wish to make the following submissions. South Africa cannot overstate the significance of this advisory opinion for the Palestinian people, more especially the legal characterization of the situation of occupation and the imposition of the system of racial oppression and apartheid, which have unconscionably been permitted to continue for far too long. The occupation alone has persisted for 56 years. As the UN Special Rapporteur on the Occupied Palestinian Territories explained in 2022, the occupation by Israel has been conducted in profound defiance of international law and hundreds of United Nations resolutions, with scant pushback from the international community. Consequently, Mr. President, that defiance by Israel has already led to the killing of tens of thousands of Palestinians, including an estimated 30,000 killed in the past 4 months alone. These are not mere statistics, Mr. President. They are flesh and blood of the Palestinian people. Therefore, we must ask, when will Israel's decades-long impunity for widespread and systematic human rights violations and violations of peremptory norms of international law end, if not now? Over the past 136 days, the world has watched in horror, daily, the relentless attacks on Gaza, the ferocity and violence of Israel's latest military campaign against Gaza, and its flouting of international law, including an order of this court, which was handed down on 26 January 2024, is the clearest indication that Israel considers itself unrestrained in its actions against Palestinians. Its actions recur with even more depravity and bloodshed, being of such a serious nature as to lead this court to find them plausibly genocidal. I remind the court that it is in our recent submissions before it, in the hearings for the indication of provisional measures in the application of the Convention and Prevention of, and Punishment of the Crime of Genocide in the Gaza Strip in South Africa versus Israel, South Africa underscored how Israel's ongoing acts and omissions in Gaza form part of a continuum of illegal acts perpetrated by it against Palestinian people since the 1948 Nakba, and since then the 1967 occupation. The legality of that occupation is now the subject of this matter before the court. Mr. President, the Palestinian cause is one which resonates strongly with the people of South Africa. That is because the Palestinian struggle invokes mournful memories of our own struggle against apartheid, segregation, and oppression. Ours is an experience aptly referred to by the United Nations Security Council in 1980 as a crime against the conscience and dignity of mankind, and as being incompatible with the rights and dignity of man. It is not without a measure of irony that one notes that this painful experience of our past has enabled South Africa to make a significant contribution to the development of international law on apartheid. From this experience, a universal legal prohibition of its practice emerged in the form of a peremptory norm and an international crime. The norm against apartheid has become one of the most cited norms of jus cogens. We as South Africans sense, see, hear, and feel to our core the inhumane discriminatory policies and practices of the Israeli regime as an even more extreme form of the apartheid that was institutionalized against black people in my country, coincidentally from the year 1948, and which lasted until 1994. The late South African cleric, the Most Reverend Archbishop Desmond Tutu, wrote the following, open quote, "Many black South Africans have traveled to the occupied West Bank and have been appalled by Israeli roads built for Jewish settlers that West Bank Palestinians are denied access to, and by Jewish-only colonies built on Palestinian land in violation of international law. Black South Africans and others around the world have seen the 2010 Human Rights Watch report, which describes the two-tier system of laws, rules, and services that Israel operates for the two populations in areas in the West Bank under its exclusive control, which provide preferential services, development, and benefits for Jewish settlers while imposing harsh conditions on Palestinians. This, in my book, is apartheid. It is untenable," end quote. That was the position already 14 years ago, since 2010. Since then, the situation of the occupied Palestinian population has worsened exponentially, with the reality of apartheid becoming so obviously explicit as to now being recognized not only by South African and Palestinian victims of apartheid themselves, but by the broader international community, including both Israeli and international human rights organizations. Moreover, it is clear that Israel's illegal occupation is also being administered in breach of the prohibition of the crime of apartheid. It is indistinguishable from settler colonialism, which has no place in the 21st century. Israeli apartheid must end. Palestine, the last unfulfilled sacred trust of civilization, for whom the international community bears responsibility, must now be fulfilled. The Palestinian people must be permitted to exercise their inalienable right to self-determination. Mr. President, South Africa bears a special obligation both to its own people and the international community to ensure that wherever the egregious and offensive practices of apartheid occur, these must be called out for what they are and brought to an immediate end, and that the perpetrators of such egregious breaches of peremptory norms of international law be held accountable. In the construction of wall case, this court held that the construction of the wall being built by Israel, the occupying power, in the occupied Palestinian territory, including in and around East Jerusalem, and its associated regime, are contrary to international law, and that Israel is under an obligation to dismantle forthwith the structure therein situated, and to repeal or render ineffective forthwith all legislative and regulatory acts relating thereto. Despite that 19-year-old finding by the court, today Palestinians in the West Bank, including many in East Jerusalem, continue to be contained behind a segregating wall. They continue to be subjected to discriminatory land zoning and planning policies, punitive and administrative house demolitions, and violent Israeli army incursions into their villages, towns, and cities, and refugee camps, including Area A, which is supposed to be under full Palestinian control. Palestinians continue to be subjected to routine violent Israeli raids on their homes, with thousands of adults and children being subjected to unlawful arbitrary arrests by Israeli soldiers in the dead of night, and indefinitely renewable internment without trial, known as euphemistically as administrative detention, and a dual legal system pursuant to which Palestinians, including Palestinian children, are tried under military legislation by military judges, often themselves illegal settlers, in Israeli military courts, without basic protection of international humanitarian and human rights law, while Israeli settlers living illegally in the same territory are subject to an entirely different legal regime and tried in Israeli civilian courts with full access to due process. Separately, Palestinians in Gaza have lived in a sealed-off enclave, fragmented and segregated from the West Bank, and subjected by Israel to regression, sustained closure, and seized. Palestinian refugees and exiles in the diaspora are systematically denied their right to return to their homes. Apartheid Israel discriminates against and fragments all Palestinian people to ensure the maintenance of Israeli Jewish domination. South Africa beseeches this court to examine the institutionalized regime of discriminatory laws, policies, and practices applied by Israel along the definition of the crime of apartheid, and to find that Israel subjects Palestinians to what constitutes an apartheid regime. The clear legal characterization of the nature of Israel's regime over the Palestinian people can only assist in remedying the ongoing delay in achieving a just settlement, a delay which perpetually conflagrates the cycle of violence. As I speak, and for each of the past 136 days, the world is witnessing in Gaza an assault that is unprecedented in speed and severity, violating the most basic precepts of the right to life and the survival of a population. The international community's unwillingness to hold Israel accountable for its policies and practices, and its failure to ensure the immediate, unconditional and total withdrawal of Israeli troops and an immediate end to Israel occupation and apartheid in Palestine, including Gaza, the West Bank and East Jerusalem, emboldens Israel to cross a further threshold, namely to commit the crime of crimes, genocide. Mr. President, distinguished members of the Court, it is now my honor to request you to invite Advocate Andrew Stemmet to the bar to submit South Africa's further observations on the questions referred to the Court by the UN General Assembly. Thank you.
I thank His Excellency, Mr. Vusi Madonsela. I now give the floor to Mr. Peter Andreas Stemmet. You have the floor, sir.
Mr. President, distinguished members of the Court, it is an honor to appear before this Honourable Court today on behalf of the Republic of South Africa. The request for an advisory opinion presents a critical opportunity to clarify and reconfirm the rules and principles of international law applying to the situation of Palestine and the Palestinian people. A clear legal assessment would assist the General Assembly and the broader international community to promote peace and justice, a key element of judicial propriety, at a time when a ferocious and unrestrained military assault has been launched by Israel on the Palestinians in Gaza, which this Court has found may plausibly amount to genocide, threatening the very existence of the Palestinian people. In this submission, we do not intend to restate South Africa's arguments on why the Court has to assume jurisdiction, as this has been dealt with in some detail in our written statement. We will therefore focus on the Palestinian right to self-determination and the violation thereof by Israel, and then we will continue to submit our arguments on the legal consequences for Israel, the United Nations, and third states. Mr. President, members of the Court, the right to self-determination, also called the Magna Carta of decolonization, is an established and inalienable right in and fundamental principle of international law. The respect for this principle is one of the purposes of the United Nations, Article 1, Paragraph 2 of the Charter. It has an erga omnes character owed to the international community as a whole, on which the Court has developed a strong and consistent jurisprudence. The inalienable right of the Palestinian people to self-determination and full independence has been recognized by the United Nations in numerous resolutions over the decades, and the most recent General Assembly resolutions of December 2023 once again recognized the right of the Palestinian people to self-determination and the permanent sovereignty of the Palestinian people in the Occupied Palestinian Territory, including East Jerusalem, over their natural resources. Self-determination accrues to a people, and in its most recent order of 26 January 2024, in the matter of application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel, the Court confirmed that the Palestinians constitute, and I quote, a distinct national, ethnical, racial, or religious group, end quote. Israel has occupied the Palestinian territory in the West Bank, Gaza, and East Jerusalem since the 1967 Arab-Israeli War, and annexed East Jerusalem and parts of the West Bank in that same year. It is not disputed that the acquisition of territory by the threat or use of force is illegal, irrespective of whether the territory was acquired through a war of self-defense or of an act of aggression. The occupying power cannot annex any part of the occupied territory, and there is an obligation on states not to recognize such an illegal territorial acquisition. Moreover, that an occupation must also be temporary in nature was confirmed by the Court in the Namibia Southwest Africa case, where it held that the end of South Africa's mandate must be self-determination and independence of the people of Namibia. A 56-year occupation is not temporary. Annexation, per definition, cannot be temporary. These principles also apply to Palestine. The Security Council has already in 1967, in Resolution 242, expressly emphasized the inadmissibility of the acquisition of territory by war and called for the withdrawal of Israeli armed forces. Furthermore, in the construction of a wall case, this court unequivocally held that the ongoing construction of Israeli settlements in the occupied Palestinian territory is in breach of international law. However, it is clear that Israel has turned the temporary nature of the occupation into a permanent situation, in violation of the Palestinian right to self-determination. It has done this through its illegal settlement enterprise, which now consists of an estimated 700,000 settlers, an increase of 235% since the Oslo Peace Accords, and of 165% since the War Opinion. That is notwithstanding that in the Wall case, this court unequivocally held that the ongoing construction of Israeli settlements in the occupied Palestinian territory is in breach of international law. In that case, the court found that Israel has taken measures that, and I quote, severely impeded the exercise by the Palestinian people of their right to self-determination, unquote, in breach of that fundamental right. The very disruption of Palestinian territorial integrity resulting from those settlements, as well as Israel's formal and de facto annexation of parts of the occupied Palestinian territory, including East Jerusalem, constitute further violations of that fundamental right. General Assembly Resolution 1514 of 1960 declares in paragraph 6 as follows, and I quote, "Any attempt aimed at the partial or total disruption of the national unity and territorial integrity of a country is incompatible with the purposes and principles of the Charter of the United Nations." Unquote. The court, in its advisory opinion on legal consequences of the separation of the Chagos archipelago from Mauritius in 1965, held that Resolution 1514 has the status of customary international law, and hence is binding on all states, including Israel. Mr. President, members of the court, turning now to the nature of the Israeli administration of the occupied Palestinian territory, it is straight law that Israel, as the occupying power, is bound by both international humanitarian law and international human rights law in its administration of the occupied Palestinian territory. The basic objective of international humanitarian law applicable to occupation is the protection of the population under occupation, including their safety and security, and their public and private property. As the record of the past half-century makes clear, Israel, as the occupying power, is not acting in the best interests of the population under occupation and is not administering the occupied territory in good faith, breaching multiple jus cogens norms of international law, including the prohibitions on annexation, self-determination, apartheid and genocide, on which I have focused. In terms of international humanitarian law, the continuing construction and expansion of Israeli settlements in the occupied Palestinian territory are in clear violation of Article 49 of the Fourth Geneva Convention, to which Israel is a party and which the court has found in the Wall case to be binding upon Israel. In terms of international human rights law, this court confirmed in the Wall case that the protection offered by human rights conventions does not cease in the cases of armed conflict, except under specific and very defined derogation principles. While it's also established law that the human rights law obligations of a state also apply in situations over which such state has control. Mr. President, members of the court, Ambassador Manoncela has dealt in some detail with the practices of apartheid perpetrated by Israel against the Palestinian people, including as the occupying power in the occupied Palestinian territory. But at this juncture, it's also appropriate to recall that the court held in the Namibia Southwest Africa case that to establish and enforce distinctions, exclusions, restrictions and limitations exclusively based on the grounds of race, color, descent or national or ethnic origin constitute a denial of fundamental rights and is a flagrant violation of the purposes and principles of the United Nations Charter. The extent of human rights violations and discriminatory laws and practices by Israel with respect to the Palestinian population is well documented in various reports of the treaty-based and charter-based mechanisms of the United Nations and is recalled in the resolutions of the Security Council and the General Assembly. These policies and practices have reached the threshold of apartheid within the meaning ascribed to it in the International Convention on the Suppression and Punishment of the Crime of Apartheid. While Israel is not a party to the Apartheid Convention, the fourth report on peremptory norms of general international law, Jus Cogens, by the International Law Commission Special Rapporteur, found that the Apartheid Convention codified what was already a crime under customary international law, and that this crime has a Jus Cogens character. The prohibition of apartheid and racial discrimination is therefore a peremptory norm of international law and binding on all states, including Israel. Mr. President, members of the Court, Israel's total disdain and disrespect for these principles result in the occupation being inherently and fundamentally illegal in terms of international law, just as South Africa's prolonged presence in Namibia was found by this Court to be illegal. Mr. President, members of the Court, further to a finding of illegality, the General Assembly also seeks guidance on the wider consequences of such a finding. We now turn to the legal consequences for Israel, the United Nations, and third states. The continued occupation by Israel and the Palestinian territory, including East Jerusalem, as well as the aforementioned violation of peremptory norms of international law, are breaches of international obligations constituting internationally wrongful acts attributable to Israel and which invoke the law of state responsibility. The law of state responsibility provides that the state responsible for an internationally wrongful act is under an obligation to seize such act and to make reparation in an adequate form, as confirmed by this Court's predecessor in the Factory at Gorjov case. In the present case, the aforementioned principles of international law require that Israel must bring an immediate, unconditional and complete end to the occupation in all its manifestations. This means that Israel must immediately cease its illegal settlement activities and all measures aimed at altering the character, status and demographic composition of the occupied Palestinian territories and dismantle illegal structures, including the settlements and the wall. Furthermore, it must immediately, unconditionally and totally withdraw its occupation forces from the occupied Palestinian territory, dismantle the settler colonial apartheid regime against Palestinian people, rescinding all legislative measures adopted with a view to annex Palestinian land and discriminate against the Palestinian people, allowing for the full restitution of Palestinian property and for the right to self-determination of the Palestinian people to be finally realized. The United Nations, especially the Security Council and General Assembly, must in all their engagements and actions on the issue of Palestine be guided by the imperative of the implementation of the sacrosanct Palestinian right to self-determination. To this end, these organs must use all measures within their powers to bring an immediate end to the unlawful Israeli occupation of the Palestinian territory, including Jerusalem, East Jerusalem. The United Nations should also remain seized of the matter and continuously monitor implementation of any order that the Court may give to end the racial discrimination and apartheid by Israel in the occupied Palestinian territory, to ensure that the illegal situation is terminated immediately, and to ensure that their resolutions are implemented without delay. Urgent consideration should also be given, in particular, to the re-establishment of the Special Committee on Apartheid with respect to the occupied Palestinian territory that will be seized with this matter. Third states must immediately act with a view to end, through all lawful means and measures, the annexation by Israel of parts of the occupied Palestinian territory and East Jerusalem, and refrain from rendering assistance or aid in any form to Israel for the maintenance of the situation. Third states have a positive obligation not to recognize Israel's continued occupation and presence in the occupied Palestinian territory, as these are breaches of Jus Cogens norms of international law. That obligation, far too long ignored must now urgently be implemented. Mr. President, members of the Court, the failure of the international community to act decisively to end the illegal occupation and annexation of Palestinian territory and to settle colonialism, apartheid practices and continuous human rights violations perpetrated by Israel against the Palestinian people as an occupying power across Gaza, the West Bank, including East Jerusalem, form the broader context and the root causes of Israel's current military onslaught on Gaza that has already claimed the lives of an estimated 30,000 Palestinian civilians and has resulted in wide-scale destruction and a catastrophic humanitarian situation. Mr. President, honourable members of the Court, it's often said that the right to life is the font from which all other rights flow. The same could be said about the right to self-determination. In the absence of self-determination, it is impossible for a people to realise a plethora of other rights. These advisory proceedings present this honourable Court with the opportunity to assist in bringing about the immediate and unconditional end to the ongoing unlawful violation of the Palestinian right to self-determination. Mr. President, distinguished members of the Court, this brings to an end the oral submission by South Africa. I wish to thank the Court for your attention. Thank you.
I thank the delegation of South Africa for its presentation.
I invite the next delegation, Algeria, to address the Court and call Professor Ahmed Larabat to the podium. Sir, you have the floor.
Mr. President, members of the Court, I have the honour of presenting the oral presentation of my country, the Democratic and People's Algerian Republic, as part of the advisory proceedings pertaining to the request of the UN General Assembly of the 30th of December 2022. I shall do this with the benefit of the following few remarks. The two questions posed by the General Assembly successively pertain to, I quote, the legal consequences of the persistent violation by Israel of the right of the Palestinian people to self-determination, of its occupation, its colonization, and its prolonged annexation, end of quote, and I quote once again, the consequences arising from the policies and practices of Israel on the status of occupation and the legal consequences that flow from them for all states and the United Nations organization. The key word of the UN resolution is that of occupation. It is abundantly cited both in its preamble as well as in its operative paragraph. Inter alia, it is the only term to be found in the two questions posed by the General Assembly. Such an importance should come as no surprise, because the prolonged occupation of Palestinian territories is the central point of their situation that has considerably deteriorated in every respect these past few months. It is the reason why Algeria will begin by addressing briefly the non-existence of compelling reasons not to respond to the General Assembly's request. That's the first point. And then it will focus on reviewing the manifestation of prolonged occupations of Palestinian territories and their consequence on its legal status. Second major point, this examination leads to the acknowledgement of a continuous, gradual and extreme violation of the rules and principles of international law, underscored by the UN General Assembly resolution. And lastly, final point, the legal consequences for all states and the Organization of the United Nations. On the non-existence of compelling reasons, in substance, four arguments were rehearsed. There's first of all the principle known as the circumvention of the absence of consent to the court's jurisdiction. First point, the existence of factual evidence. Second point, the conflict that exists between this request and the existence of a negotiating framework. Third point, and lastly, the absence of aim and purpose of the request. Algeria recalls that these have been constantly discarded by the court, notably in its opinions of 2004 and 2019, to mention but two of the most recent ones. There's no circumvention of the absence of consent to the court's jurisdiction, constantly invoked in advisory proceedings, notably in that pertaining to the unlawfulness of the construction of the wall in 2004. This argument has quite constantly been discarded by the court. As the High Court declared on a number of occasions, the possibility of the existence of a concomitant bilateral dispute to an advisory proceeding is in the nature of things. In this regard, it would be hard to find further reasons that might legally justify the reiteration of this argument. Second point that we can term the factual question. This argument is also a classic one, regularly put forward to invite the court to refuse to accede to a request for an advisory opinion. The court has always refused this. It notably declared in paragraph 58 of its 2004 opinion that, and I quote, "The circumstance that others may evaluate and interpret these facts in a subjective or political manner can be no argument for a court of law to abdicate its judicial task." End of quote. On the third argument, that pertaining to the existence of a negotiating framework, another major classic in this regard, the existence of a negotiating framework put in place by the Oslo Accords was once again put forward in order to invite the court not to accede to the request of the General Assembly. The court took clearly a position in paragraph 53 of its 2004 opinion by declaring that participants to the proceedings expressed in this regard divergent views, and the court, and I quote, "cannot regard this factor as a compelling reason to decline to exercise its jurisdiction," end quote, on the absence of aim and purpose of the request of the General Assembly. This argument, that of the absence of aim and purpose, is not new either. Here again, the court should not accede to it. We can notably refer to paragraph 60 of its advisory opinion of 2004, where the court rejected it by stating, and I quote, "As it emerges from the court's jurisprudence, advisory opinions serve to supply the organs that request the elements of legal character that are necessary as part of their activities. End of quote. It added in paragraph 62 that, and I quote, the court cannot decline to answer the question posed based on the ground that its opinion would lack any useful purpose. The court cannot substitute its assessment of the usefulness of the opinion requested for that of the organ that seeks such opinion, namely the General Assembly, end of quote. At the same time, that brings to an end the first part of the presentation. Part two, the manifestations and consequences of prolonged occupation of Palestinian territories. And firstly, observations on the occupation of Palestinian territories. It's an ambiguous notion, if ever there was one, because located in theory at an intermediate stage between war and peace, the notion of occupation found its basis in Article 42 of the Hague ruling of 1907, whose customary notion is not contested, as the court recalls in paragraph 89 of its opinion on the construction of the wall. Without dwelling on the legal regime of occupation, it is important to highlight with a broad brush its most fundamental aspects. In substance, occupation was originally devised in a context that needs to be underscored, in which there did not yet exist the principle prohibiting the use of force. It was devised as a temporary regime in which the occupying power, as we know, does not exercise its sovereignty. One may, inter alia, underscore that it was devised to manage temporary situations between the end of hostilities and the conclusion of peace treaties. It would almost suggest a peaceful relationship between occupier and occupied, regarding which the idea of prolonged occupation was totally inconceived by the drafters of the time. It's the reason why the right of occupation addresses neither the question of its prolongation nor, with stronger reason, that of its permanency. The multiplication of armed conflicts has brought about new forms of occupation. The realities are far more complex, and the state's contemporary doctrine, as the ICRC, regularly question certain deficiencies of the law of the years 1907 and 1949. The Palestinian situation is a striking illustration of the violent contrast that exists between theoretical appearances that have just been sketched out with a very broad brush and a reality. Algeria considers that the situation created in 1948 and continued to shows up starkly the misuse and abuse of the concept of occupation by Israel in occupied Palestinian territories. Israel's goal is to reach a point of no return in order to discard all possibility of the creation of the Palestinian state. This objective has several forms decided on the basis of situations specific to each part of occupied Palestinian territory. That's to say, East Jerusalem, the West Bank, and the Gaza Strip. And so, occupation is becoming if it hasn't already become so, an avatar of former legal techniques that expressed each in their own way the right of power. Second point after those brief observations, the colonization of East Jerusalem and the West Bank and the situation in the Gaza Strip. First corollary of prolonged occupation. In the three parts of Palestinian territory, we find the same policy and the same practice that we can summarize with the formula of fact against law. In East Jerusalem, with the war of 1948, the UN plan for partition, Resolution 181 by the General Assembly, was first stopped in its track, and the fait accompli illustrated by the occupation of the western part of Jerusalem by Israel in violation of Resolution 181, at the same time by the adoption of legislative and administrative measures, including expropriation. After the 1967 war, Israel began to apply its domestic law with the application, but not exclusively, the adoption of two laws adopted on the same day, 27th of June 1967. This policy will be strengthened even further with the law dated 30th of July 1980, making Jerusalem the capital, quote, full and reunified of Israel, but in fact it should be characterized as de jure annexation. I'll return to that. The law of 27th of November 20 amended it with the view to consolidating it even further, and I quote, to prohibit the transfer of all form of government power, end of quote. This law of 2000 was once again amended in 2018 to strengthen its scope even further. So, fait accompli on the one hand, followed by the establishment of Israeli legal rules in the West Bank. Here again, two successive phases. Planned military occupation is followed by the beginning of colonization with the building of hundreds of settlements and the displacement and confinement of the Palestinian people, as well as the destruction of their buildings. The most striking feature in the West Bank resides in the spectacular increase in the establishment of settlements between 2012 and 22. The numbers went from 520,000 settlers to 700,000. That's quite dizzying a figure. And the consequences were of several orders to move the human beings and also to displace as well as confine the Palestinian people. And last but not least, the construction of infrastructure and the exploitation of natural resources. All historians of colonization stress the compelling importance of the dispossession of land in establishing and accelerating colonization. That of Algeria is a particularly striking example. As to Gaza, third point, the Israeli withdrawal of the Gaza Strip in 2005 was immediately followed by the blockade and 4 large-scale military operations, of which the latest is ongoing. How can we focus on the fate of Gaza without evoking the current situation? The facts, first of all, in truth, they speak for themselves, and the images speak volumes. Res ipsa loquitur. Next, figures that are overtaken the day after their announcement, over almost 30,000 dead and twice as many wounded, the destruction of almost half of all essential infrastructure goes hand in hand with famine, lack of water, really below the minimum level of necessities. The situation of Rafah is the latest preoccupation of the international community and international organizations. Its gravity is due to the latest plan by Israel to launch a large-scale military operation of a civilian population of 1.4 million people, stunned and buffeted. A Gaza Strip that had devastated for a long time. And paraphrasing Cato the Elder, obsessed by Carthage, whose leitmotif was the term Carthago delenda, as we can say today that Gaza destructum est. On annexation. Annexation is the second corollary of prolonged occupation, the first being colonization. The legal consequences stemming from the dramatic developments of prolonged occupation raises the question of the development of the latter. It's not a new question. It is evoked, sometimes suggested, sometimes frankly considered after every war, notably by Israel. But over and above that, the situation of prolonged occupation since 1967 imposes it inevitably in the debate. In its resolution of the UN, the General Assembly expressly referred to the impact of Israeli policies and practices on the legal status of occupation. Regarding the court's jurisprudence, Algeria would recall that in its advisory opinion of 1950 on the international status of Southwest Africa, and as I quote, where it was expressing itself generally on the mandates, and I quote the court had underscored that two principles was deemed as of paramount importance, and I quote, that of non-annexation, paragraph 131 of that opinion. Algeria recalls next the paragraph 121 of the opinion on the 2004 war. The court felt that the construction of the wall and the regime associated thereto creates on the ground a fait accompli in inverted commas, creates on the ground a fait accompli that might well become permanent, in which case, and notwithstanding the official description that Israel gives of the wall, the construction of this wall would be tantamount to de facto annexation. In end of quote. In this excerpt, the court considers, first of all, that the construction of the wall and its legal regime are fait accompli. It then refers to the possibility of their permanency. And it concludes by using the conditional that the permanence would transform the occupation regime into de facto annexation. In other words, it's the permanence that conditions the passage from occupation to de facto annexation. So inevitably, This refers to the question of the duration, and we know, as we saw earlier, international law of occupation remains silent. The notion of permanence must be assessed in light of the factual context of the situation, 2004, that the court set out. And in paragraph 69 of the opinion, the court referred to structures built or under construction, specifying further, and I quote, that the Israeli Council of Ministers on the 23rd of June 2002 approved the first construction phase. That's to be found in paragraph 80, and that the construction of the wall was accompanied by the establishment of a new administrative regime, end of quote. And so one can better understand the prudent wording of paragraph 121. In 2004, it was still permitted and legitimate to ask about the completion of the construction of the works, given the date, 2004, and a possible felicitous outcome of the negotiating process. Such prudence can, with difficulty, still be applied when the construction of the wall has continued and the regime associated with it was consolidated. This situation has wall and its legal regime. Similarly, it is possible to question and ask about the legal regime of the West Bank, that its prolonged occupation has been ongoing for 57 years, and the West Bank prolonged occupation with its construction of settlement and destruction has led to de facto annexation. It is in the nature of things, alas, that colonizations, destructions, constructions are not destined to be temporary. In this regard, we can recall the conclusions of the International Independent Commission tasked by the General Assembly to investigate the occupied Palestinian territories in September 2002 that noted acts tantamount to annexation. The continuous, gradual, extreme violations of relevant international law, an obstacle to the creation of the Palestinian state. Three areas to briefly address here. Firstly, the violation of the right to self-determination, an erga omnes paramount rule. One could have recalled the various stages of the legal development of this law. It was done so on several occasions in the written submissions, the written observations, and up until yesterday in Palestine's oral presentation. Both the Charter as well as Resolution 1514, 1804, and the jurisprudence of the Court of its successive opinions of Namibia in 71, Western Sahara in 75 contributed to this, and of course particular contribution must be on East Timor of 1995, because that's where the court considered that the right of the people is enforceable erga omnes. No need to stress that the International Law Commission enshrined the right to self-determination amongst the imperative laws at the end of its work devoted to the imperative laws in 2019. Extended prolongation, the source of unlimited international law and international human rights law. Israeli policies and practices violated the most fundamental aspects of these two branches of international law. It would truly be pretentious to have us believe in the remaining time to give a broad spectrum of all these violations. I think we can refer here to the previous submissions by Algeria, but also those of Palestine, including those delivered yesterday. On the legal consequences now, for Israel, it is under obligation to put an end to violations of international law, has a duty to repair all the harm suffered by the Palestinian people, and also under obligation to deliver on all the obligations that are violated and to repair the harm, and for the other states not to recognize the situation created by this, not to render assistance to Israel. A number of recent events that show the question of not rendering assistance to Israel is beginning to take shape for the UN, for the General Assembly and the Security Council. The aim is to increase the decisions. In general conclusion, Mr. President, ladies, judges of the court, Algeria is profoundly convinced that impunity is the fourth law of oppressors. Your duty is to tell them there is a law and this law must be upheld, that this law is not a law of vengeance, but of justice. It's in that spirit that Algeria repeats the request made in its previous submissions. Thank you, Mr. President, members of the court.
I would thank the Algerian delegation.
Participating delegation, Saudi Arabia, to address the court. I call upon His Excellency Mr. Ziad Al Attiyah to take the floor.
Mr. President, members of the court, it's a great honor for me to appear before you to present my country's position on a matter of utmost importance of all states and the United Nations. In my remarks today, I will expand on a few critical points made in our written statement and address at the outset one matter that postdated our submission, but which is impossible to ignore when considering the questions before the court. That matter is, of course, Israel's military aggression against Gaza and its increasing acts of violence directed against the Palestinian population of the West Bank, including East Jerusalem, since October 2023. I believe I speak in consonance with virtually the entire international community in expressing the Kingdom's profound revulsion and condemnation of the horrendous death, destruction and displacement of Palestinian civilians brought about by Israel's illegal and brutal war in Gaza, and the notorious increase in Israeli aggression, impunity and international law violations in the West Bank, including East Jerusalem, since October 2023. Israel defends this obscene brutality as the necessary price for defeating Hamas. The Kingdom of Saudi Arabia firmly rejects this twisted logic. Israel's actions in laying waste to the Gaza Strip, killing and maiming tens of thousands of innocent civilians, depriving them of food, water, and the basic means of survival, while displacing virtually the entire population of the 2.3 million people, are not justified under any circumstances. Israel's actions have severely dehumanized the Palestinian population, treating them as dispensable objects rather than human beings. These disgraceful acts, which have brought about formal accusation before this esteemed court that Israel is committing genocide against the Palestinian population, as well as an order of professional measures recognizing the plausibility of those accusations and ordering Israel to comply with its obligations under the Genocide Convention, necessarily weigh heavily upon the consideration of the questions before the court in this proceeding. For if nothing else, they demonstrate all too vividly how the illegality of the Israeli occupation over more than 5 decades can degenerate into the ugliest of consequences. A final point I wish to highlight at the outset is that all written statements submitted before this court, not one state has sought to defend the legality of Israel's policies and practices in the occupied Palestinian territory. This is a telling acknowledgement of the international community's unanimous recognition of the illegality which pervades that occupation. Israel itself does not attempt to defend the substance of its policies and practices. As the court will have observed, its 5-page submission does not, no doubt because it cannot, say anything whatsoever about the substantive allegations made against it. Instead, it focuses almost entirely on why the request of the advisory opinion and the questions contained therein are somehow improper. The only logical conclusion that can be drawn from all of this is that Israel's policies and practices in the occupied Palestinian territory are legally indefensible. This brings me to the next part of my statement. The Kingdom of Saudi Arabia submits that the court has jurisdiction to issue the opinion, and there are no compelling reasons for it not to do so. To the contrary, given the recent increase in bloodshed and destruction by Israel in the occupied Palestinian territory, as well as the dangerous statements made at the highest levels of the Israeli government, we respectively submit that the court is under a duty to issue its opinion. I will now discuss the arguments advanced by some states that the court should not issue the opinion for 2 primary reasons. First, because the opinion might prejudice a negotiation process aimed at resolving the Israeli-Palestinian conflict, which those states consider to be ongoing. And second, because the questions posed concern a bilateral dispute between Israel and Palestine. Not only are these arguments misguided, but they have been repeatedly rejected by this esteemed court under highly analogous circumstances, including in the World Advisory Opinion. The Kingdom regards the first argument as being based on a blatantly false premise and devoid of any legal foundation. Its lack of legal credibility has been addressed by the League of Arab States in its October 2023 comments. In the interest of time, I would respectively direct that court's attention to those comments, which we fully endorse. Simply put, the court's prior practice should prevail in this instance. The practice gives deference to the General Assembly when requesting guidance from the court an issue the Assembly considers irrelevant to its work. As the following demonstrates, the assumption that a serious negotiation process exists is a fiction that offends reality. In the 2004 World Proceedings, the Kingdom of Saudi Arabia described Israel's modus operandi in the occupied Palestinian territory since 1967 as, quote, deliberately enhancing its position and changing the territorial status quo to its benefits, end of quote. The court rightly recognized this reality in its advisory opinion, referring to the illegality of Israeli settlement practice in the occupied Palestinian territory. The court also warned quote, the construction of the wall and its associated regime create a fait accompli on the ground that could become permanent, in which case it would be tantamount to de facto annexation. End of the quote. This assessment was precedent and tragically but predictably resulted in no change in Israel's illegal conduct. Now here is this seen more clearly than in the number of legal settlers residing in the occupied Palestinian territory, which has grown from roughly 424,000 in 2004 to some 700,000 settlers today. Since 1967, far from engaging in negotiations, Israel has made it virtually impossible to establish a cohesive Palestinian state. It has done so by annexing more than 2 million dunams of land, building more than 279 illegal settlements throughout the West Bank, illegally annexing East Jerusalem and declaring Jerusalem as its undivided capital, confiscating natural resources, demolishing Palestinian homes, and much more. Those actions are well documented in the many UN reports discussed in the Kingdom's written statement, and I will not dwell on them further, except to make the self-evident point that the Israelis' actions have clearly aimed at frustrating a negotiated settlement rather than opening the door to such settlement. These policies and practices should be enough to dismantle the illusion that Israel has any intention of engaging in serious efforts towards a negotiated peace. But Israel has also, for good measure, approached actual negotiations with nothing less than impunity and contempt. Mr. President, members of the court, we see this not as spectators, but as a direct participant in efforts towards negotiating a lasting peace spanning decades. That was the case when more than 20 years ago, the Kingdom of Saudi Arabia proposed the Arab Peace Initiatives, which was adopted by the Arab League in 2002 and re-endorsed at the 2007 and 2017 Arab League summits. However, this peace initiative was rejected outright by Israel, with its then Prime Minister describing it as a non-starter, because it required Israel to forgo occupied territories in exchange for peace, a policy that has persisted until today. The reality today has become more discouraging. At the senior levels of the Israeli government, calls are openly made to forcibly transfer or ethnically cleanse Palestinians out of their homeland, expand settlements even further, annex further areas of the West Bank, and at all costs to reject the notion of establishing a Palestinian state along the lines of the two-state solutions. And while the brutal and genocidal onslaught of Gaza by the Israeli military since October 2023 has led it to become, in the words of the United Nations Under-Secretary General for Humanitarian Affairs, a place of death and despair. It should not be forgotten that Israel's aggression has been accompanied by unyielding statements by its leaders that it will never agree to a sovereign Palestinian state or cede control over the occupied Palestinian territory. Such a statement hurriedly reflects Israel's intention to engage in a genuine peace negotiations. Concluding at this point, I would add that if a serious negotiations aimed at achieving a just resolution of the Israeli-Palestinian dispute in accordance with the international law were to become reality, the court's opinion could not in any case possibly prejudice those discussions, but rather would enlighten them. Mr. President, member of the court, the second argument raised by certain states is that the court should refrain from rendering the requested opinion because it relates to a strictly bilateral matter between Israel and Palestine. This argument has been rejected by the courts in several barrier contexts, including the World Advisory Opinion, and should, we believe, be disposed of by the court in the same manner in this case. Not only is the argument legally unfounded, but the fact that the questions posed to the court are of a multilateral nature is self-evident. As explained in the Kingdom's written statement, the legal questions are located in a broader context, involve erga omnes obligations and Judge Nawaf norms, and ask about the consequences of Israel's policies and practices in all states as well as the United Nations. To conclude on the question of the court jurisdiction, I have with one thought that the Kingdom also voiced in the context of the World Advisory Opinion. If this court, the principal judicial organ of the United Nations, should not consider the critical questions put before it, then we cannot but conclude that the system to maintain international peace and security set up following the atrocities of the Second World War has not stood the test of time. Mr. President, members of the court, I will now address the first questions before the court, which concerns the legal consequences arising from Israel's prolonged occupation and illegal policies and practices in the occupied Palestinian territory. To answer these questions, the court has a plethora of evidence available. This includes the evidence furnished by the United Nations, its organs, UN human rights mandate holders, and the specialized agencies, the special rapporteurs, and the independent commission, all available in the dossier before this court or referred to in the Kingdom's written statement. We submit that the catastrophic consequences of Israel's policies and practices on the ground, as well as their sheer illegality, are undeniable. The international community has seen stark evidence of these consequences during the current war in Gaza. The ongoing situation is so appalling that last December, the UN General Assembly overwhelmingly passed a resolution demanding an immediate humanitarian ceasefire in Gaza, while the court has recognized the possibility that Israel's conduct amounts to a genocide and ordered it to comply with a series of professional measures. However, as we speak, Israel continues to defy the international community's call for a ceasefire and to willfully ignore the professional measures ordered by the court. More generally, Israel has, over the decades of its occupation, resisted egregious violations of its most fundamental international obligations, as explained in our written statement. Israel in continuous breach of several Judge Nawaf norms, notwithstanding multiple Security Council and General Assembly resolutions condemning its conduct and this court's finding in the World Advisory Opinion. These violations include Israel taking continuous measures to prevent the Palestinian people from exercising their right of self-defense through various policies and practices, including, among others, the illegal settlement practice in the occupied Palestinian territory, the expulsion of Palestinians from their homes, and theft of Palestinians' property, the denial of sovereignty over their natural resources, and the breach of their civil, political, economic, social, and cultural rights. Moreover, Israel has continued implementing its infamous settlement practice in the occupied Palestinian territory, despite the repeated condemnation of this practice by the Security Council and this court's determination of their illegality in the World Advisory Opinion. Yet, Israel makes no secret of its intention to maintain and expand settlements as well as its possession of all or part of the occupied Palestinian territory, in violation of the Fourth Geneva Convention and the prohibition on the acquisition of territory by the use of force. Israel's 2018 Basic Law also shows Israel's disdain for the Palestinian people's right to self-determination by declaring the holy city of Jerusalem complete and united as Israel's capital, stipulating that, quote, the exercise of the right to national self-determination in the state of Israel is unique to the Jewish people, end of the quote. It's also incompatible with the Palestinian people's right to self-determination in the occupied Palestinian territory, including East Jerusalem. The international community has spoken on these issues on many occasions through the United Nations principal bodies, demanding that Israel completely ceases all settlement activities, revoke its annexation of East Jerusalem, and comply with its international obligations in other respects. The list of resolutions is long. We have addressed many of them in our written statements. Israel continues to ignore them. But Israel's breaches of international law don't end there. There can be no serious debate that Israel's policies and practices also amount to the racial discrimination and are tantamount to apartheid in the grave violations of the Palestinian people's human rights. Israel's seizure of land and resources for Israeli settlers and discriminatory application of laws, regulations to the detriment of the Palestinian people are merely examples of this egregious conduct. Israel violates the human rights of the Palestinian people in multiple other ways and in breach of its conventional obligations, including the rights of women and children. Mr. President, members of the Court, the Kingdom of Saudi Arabia wishes to emphasize that the international law obligations, particularly those embodied in the preemptory norms of general international law, are not abstract rules and are not intended to be. Their violations entail particular legal consequences, but also has real and tangible consequences. The latter include, most prominently, the denial to human beings of the right to life and dignity, and more widely, the creation of threats to peace and stability, with unpredictable consequences. The multiple and grave violations by Israel of its international obligations in the occupied Palestinian territory is therefore of undeniable concern, not only to those directly affected, but also to the international community as a whole. I will now move on the second question before the Court regarding the manner by which Israel's conduct affects the legal status of its occupation. The Kingdom respectively submits that the only conclusion which may be reached from the multiple and grave breaches of international law emanating from its occupation is that Israel's occupation itself is illegal and must be brought to an unconditional end. Any other conclusion would be anomalous and inconsistent with the clearly illegal origin and conduct of the occupation, including the violations of Judge Nawaf norms that Israel has and continues to engage in through its occupation. To be clear, Israel's occupation was, from its commencement in 1967, an illegal use of force and continues to be so. The Kingdom noted this in its submission in the Wall Advisory Opinion. The illegal nature of the 56-year occupation has only been aggravated by Israel's numerous other international violations, including Judge Nawaf norms. Given the illegality surrounding every aspect of Israel's occupation, that occupation is simply indefensible as a matter of international law. For those reasons, we respectively ask the Court to expressly declare that Israel's occupation of the Palestinian territories is illegal. The court is also asked to address the legal consequences of Israel's breaches. I will address these briefly. The Kingdom of Saudi Arabia and numerous other states have laid out in the written statement the legal obligations which flow from Israel's breaches. Pursuant to Article 30 of the Articles on State Responsibility, and as explained by this court in the Wall Advisory Opinion, Israel must cease its wrongful conduct, resume compliance with its obligations, and offer appropriate assurances and guarantees of non-repetition. Article 31 and 36 also require that Israel makes full reparation for the damage caused over the decades of its illegal occupation. As for all other states, Israel's breaches of just cause norms entails that the international community has an obligation not to recognize that illegal conduct. All states must also cooperate to bring Israel's violation of international law to an end and make sure that they don't render aid or assistance in furtherance of Israel's breaches. The consequences for the United Nations are clear. All UN organs must, within their competences, take steps to bring Israel's violations to an end, and they must also refrain from recognizing these violations or giving aid or assistance to maintain the illegal situation. Finally, they must also require the unconditional and immediate end to the occupation itself. Mr. President, members of the court, thank you for your attention. This concludes the statement of the Kingdom of Saudi Arabia.
Its presentation, before I invite the next delegation to make its oral statement, the court will observe a coffee break for 10 minutes. The sitting is suspended.